Probably the most important thing you can do at the beginning of the divorce or in anticipation of the divorce is to close any joint accounts that you have with your spouse. If he or she is a signatory on an account that's in your name alone, take them off. You don't want to be a signatory on theirs either. Hopefully the two of you would work together to divide those kinds of financial accounts so that neither of you are responsible for the other party's charges contractually. So the first step would be to close any joint accounts. That would include informing the creditor that you're not going to feel yourself responsible for charges made by the other party. That you understand the account will stay open until it's paid in full and then be permanently terminated. So that probably is the most important thing. You also want to try to not use your credit cards, this is before the divorce or during the divorce or even after, to an extent that it causes financial hardship. Sometimes one spouse or the other might feel, oh, I'm going to charge a lot, sort of as punishment for the whole thing. That's not a good motivation. That doesn't benefit either party. Certainly the post-separation debts are going to be charged to the person who incurs that debt. So you don't want to be that person owing the money, and you certainly don't want to be the person having to pay for the other party's charges. At the date of separation, this is under California community property law, at the date of separation, the debt balances that exist for debts incurred during that marriage before the separation are community debts. That means that each of you is responsible for half of that debt under the California community property laws. Now, each of you is 100% responsible for that debt as far as the creditor is concerned. If your name and his or her name are both on that debt with Nordstrom's, and that debt is assigned to you in the divorce, and you don't pay it, Nordstrom's has the contractual right to go after the other party. He or she would then come after you to be reimbursed. So at the date of separation, if you have $10,000 in credit card debt, arguably under California law, you each owe $5,000 of that debt. In the judgment, that debt is going to be assigned to one party or the other. Let's say it's assigned to you. That means that the other party owes you half of that, $5,000. That may be made up for by you getting some other asset, a car worth $10,000. That would make you whole. You got a $10,000 car, you got a $10,000 credit card debt, you're even. So it's going to be divided equally as best they can. In some fairly rare situations where the indebtedness of the community estate exceeds the assets, the court does have jurisdiction to make an unequal division of debt and assign more debt to the party who's best able to pay it. But as I said, that's unusual. Generally speaking, under our laws, all debts, as well as all assets that are community, will be divided equally, or as close to equally as the court can fashion.